questions,
Yeah, take a couple of
but we won't actually be too late when we're done with this. Yes, sir.
Professor Barnett, my question encompasses both your repeal amendment and healthcare mandate activities. Specifically, under your repeal amendment, could 2/3 of the states repeal just the mandate, or would they have to repeal the entire healthcare?
They can repeal, under the wording of the repeal amendment, they could repeal any federal law, any specific provision of law or regulation of law. So they could repeal any portion of any law, any regulation. It could be as narrow, as broad, as is specifically identified if 2/3 of state legislatures agree to that same provision, and including the mandate. Yes, sir.
Randy, I'd like to add a personal anecdote to your argument about the origins of the Republican Party and the meaning of the 14th Amendment, privileges and immunities clause. So I go back a few years when I was a very young Republican back in Brooklyn, New York. The Republican Party had some older members, blacks who were older members before back from the day when most blacks were in the Republican Party. And their comment on the Civil Rights Act of the 1960s was, why don't they just enforce the 14th Amendment? They had your understanding of that.
Right.
So if you go back in the black community, there's a sense of betrayal of what had been won in the Civil War that was felt through the 60s with the older generation of that time.
There was a complete betrayal, and one of the things that's forgotten is not only what the original meaning of the 14th Amendment was, but the fact that Republicans passed their own civil rights acts that were very similar to the ones that were passed in the 60s, and they were invalidated by the Supreme Court. And one of the reasons why the new civil rights acts had to be passed under the Commerce Clause power, which greatly expanded the Commerce Clause power, and not under the Section 5 enforcement power of the 14th Amendment, is those old Reconstruction era cases had limited the enforcement power of the 14th Amendment, and to get around that precedent, they used the Commerce Clause power instead. It's a very, the Supreme Court does not come off so well in the retelling of this story. Yes, sir.
Professor, could you explain in briefly in layman's terms the potential benefits of that wonderful opinion of Clarence Thomas in McDonald?
Well, I mean, Justice Thomas is the only justice who has not accepted the constitutional jurisprudence of the New Deal. All of the other justices on the right, obviously the justices on the left side of the court have, and all the justices on the right side of the court have except for him. Some of them are willing to draw a line at this point and say no farther than that. In the individual mandate, our argument is a point farther than where we've gone before. And I think there's a reasonable prospect 5 justices will say no farther, as long as saying that isn't going to undermine their constitutional commitments to the New Deal. And it wouldn't, actually. But Justice Thomas is not convinced that this expanded power for the federal government is consistent with the Constitution, and therefore he wrote an opinion in the McDonald case. He also wrote concurring opinions in the Lopez and Morrison case. He wrote concurring opinions in the Lopez and Morrison cases about how the whole substantial effects doctrine, which gives Congress the power over interstate activity, should be rejected, not just limited. And then in the McDonald case was a case involving whether the individual right to keep and bear arms, having been established as a Second Amendment right against the federal government in Heller, was also applicable to state governments. And the parties, the principal parties, Alan Gura, a graduate of Georgetown Law School, argued that under the original meaning of the Privileges or Immunities Clause that I was just talking to you about, the right to keep and bear arms was one of the principal rights they had in mind, because they wanted to get guns in the hands of free blacks so they could protect themselves, in some cases from the militias. Well, the Supreme Court felt more comfortable sticking with its due process clause jurisprudence because it already had established limits on that. Justice Thomas is the only one who issued an opinion who said, no, we should really revive the original meaning of the Privileges and Immunities Clause. And that would imply that there were other rights besides the right to keep and bear arms, including other liberty rights, that would be protected, just as the Ninth Amendment was supposed to protect liberty rights against the federal government. And so in that respect, Justice Thomas's opinion it would be a marked improvement over what the majority ended up deciding, which was to continue to suppress an entire clause of the Constitution which has not been used except for one time in 130 years since the slaughterhouse cases. Maybe 2 more questions. Yes?
I read just this morning that Judge Hudson's ruling said that while he wasn't issuing an injunction, that his decision still should withhold the government from moving forward with the healthcare bill simply because the government had to follow the law. And that hasn't been promoted very much. It was on some internet email that I got. And I'm just wondering what your opinion is on that. Why did he not issue the injunction knowing that the government frequently violates the law?
It's Judge Vinson's opinion, not Judge Hudson. They both are good judges. They both held the mandate was unconstitutional. Judge Hudson's in Virginia, Judge Vinson is in Florida. But Judge Vinson's opinion is much more elaborate, and he's the one that refused to sever the mandate from the rest of the bill and held the whole bill unconstitutional as a result. All I know about why he did what he did is what he said in his opinion. And he said that there is no need to issue an injunction because it is presumed that the government will follow an order that's issued by a federal court. Now, that's not proving to be the case so far, and we'll have to see what happens. I have to tell you that I've been asked quite a lot in the last 10 days, what is the legal status of that decision versus the federal government's implementation, also versus the state's implementation of its obligations under the Act. And I have to tell you that it's not something I know that much about, or anyone knows that much about, because we really haven't seen this issue arise before. But I do think it will be clearer what the implications of this are shortly. I think, by the way, if Judge Hudson had issued an injunction, the government then would immediately have been able to go to the 11th Circuit and gotten a stay of that injunction, and might well have gotten it. So it's possible that he did so for strategic reasons, that there wouldn't have been anything to appeal at that point, that he couldn't have appealed an injunction. Yes?
With the way the bill is structured, particularly with the guaranteed issue mandates on the insurance companies, just as a practical matter, if the mandate was found unconstitutional, even if the Supreme Court didn't sever it, wouldn't Congress have to repeal it or watch the entire medical health insurance system go straight to hell?
Yeah, that's the reason why it's not. That's, by the way, both a practical reality and the reason why it's not severable. And it's the reason why there was no severability clause put in the bill. Most bills have a severability clause that says if any part of this bill is struck down, the rest of it will remain. There was no such severability clause in this bill, on purpose, I believe, because of this consequence and because it was a deal made with the insurance companies to get their support for the overall package, that if they're going to have to bear the cost of these regulations, they're going to get a whole new source of revenue from these new customers that are going to be compelled to do business with them. So that's the reason why I believe, and that's what Judge Vinson suggested was the reason why they're going to be, he didn't say it quite the way I did. But that's kind of the reason why he said that there was no severability clause. So you're right, and I think that's what Judge Hudson was thinking when he didn't sever the mandate from the rest of the bill. But still, having refused to sever it, it's clear that Judge Vinson's opinion has upped the ante and upped the pressure and changed the political, again, continued the political dynamic which is going against the bill. But let me make one final point and then I can wrap this up. Because this is a point that I think we all have to keep in mind. The litigation, the judicial process about the constitutionality of this bill is not disconnected from the political activism against the bill. They each are feeding the other. When there was a constitutional objection made to the bill, even before it was enacted in the Senate, that immediately became a rallying cry for those who opposed this both bad and unconstitutional bill. That's an extra reason to be opposed to it. So the constitutional issues create more political opposition. By the same token, the Supreme Court is usually inclined to bend over backwards to uphold any act of Congress, especially popular ones. But if an act is really unpopular and has given rise to really mass discontent, doesn't have to be by everybody, but by a significant portion of the American people, and was passed on a party line vote, and causes one house of Congress to flip, et cetera, et cetera, et cetera. When all that happens, I don't believe the Supreme Court would strike it down because it's unpopular. But I do think, because it's unpopular, they would be receptive to a valid constitutional objection to the bill that they otherwise would try to get around if the bill were popular. That's the reason why continued political opposition is absolutely essential to the ultimate success of the litigation. And we actually are sort of have a race to see what happens first. Is the bill actually repealed because of opposition before it's held unconstitutional, or is it held unconstitutional before it's repealed? And we don't really care which it is, because this bill represents a threat to the fundamental nature of our country and our relationship with our government. And so either way this happens, it'll be a good result. Thank you very much.